You're welcome to my channel. In this video we are going to be looking at the implied conditions and then the implied warranties. We said that implied terms are not stated in the contract, but they are presumed to be part of the contract by law, by custom, or by court interpretation. Condition as to title is the first one. So this one implies that the seller has a right to sell the goods, or will have a right at the time of the transfer of property or ownership. So this is specifically important to ensure that the buyer is not purchasing stolen goods. So condition as to title, this implied condition ensures that the seller has the right to sell the goods at the time of the transfer, and the goods are free from undisclosed charges or claims by third parties. So if this condition is breached, the buyer can reject the goods. They can treat the contract as repudiated and then claim for the damages. This was seen in the case of Roland versus Duval. So the defendant sold a car to the plaintiff. So this is the plaintiff and this is the defendant. So the defendant sold a car to the plaintiff, but the car turned out to be stolen. So since the seller did not have the legal ownership or the title of the car, they could not transfer the valid title to the buyer. So the outcome was the buyer was entitled to refund because the seller breached the condition as to title. The seller did not have the ownership or the title to transfer to the buyer since the car was stolen. So the seller was supposed to refund the money to the buyer since the seller breached the condition as to title. The second implied condition we have is the condition in a sale by description. So when goods are sold based on description, they must match the description. If the goods do not match the description, the buyer can reject them and may claim for damages. If I say that I want 2 kilograms of sugar and I give you money for 2 kilograms of sugar and you end up delivering 1.5 kgs of sugar, it is not matching the description that I gave. So the buyer has a right to reject those goods and claim for damages. This was seen in the case of Levi Kali and ORS versus Salem Mohammed in 1959. So here, the seller delivered goods that did not match the agreed description in the contract. So the outcome was the court ruled in favor of the buyer, allowing the buyer to reject the goods because they did not match the description they provided. So a condition in a sale by description: if the goods are being sold by description, they must match the description that has been provided, and the buyer has a right to reject the goods and claim for damages. We have a condition in a sale by sample. This one implies that the bulk of the goods must match the sample in quality, and the buyer must have a reasonable opportunity to inspect the goods and compare them with a sample. For example, if someone is selling clothes and they have some clothes on display, so you touch that cloth and you see that it is good, the quality is good and everything is good. Then you say, I want 10 dresses like this dress, and then they give you dresses that do not match the dress that you saw on the display. You have a right to reject those goods and then claim for damages. It implies that the bulk of the goods must match the sample in quality, and the buyer must have a reasonable opportunity to inspect the goods and compare them with the sample. So if I want dresses like the one on the display, I must be given an opportunity to look at the dresses that they've given me to see if they match the dresses that I admired on the display. So this was seen in the case of Jaferai Abdul versus Jan Mohammed. So here the seller failed to provide the buyer with a reasonable opportunity to examine the goods, and the goods delivered did not match the quality of the sample, so the buyer wasn't given an opportunity to inspect the goods. So they ended up delivering goods that did not match the sample. So the outcome was the buyer was entitled to reject the goods because the conditions of sale by sample were not met. We have another case of Drummond and Sons versus Van Ingen in 1887. So here, the bulk of the goods appeared to match the sample, but contained hidden defects that rendered them unsuitable for the intended purpose. So here, the buyer inspected the goods to see if they match the sample, and they appeared to be matching the sample, but they had some problems that were not displayed. So they had some hidden defects that rendered them unsuitable for the intended purpose. So the outcome was, court ruled that the buyer could reject the goods due to those defects that affected the quality, even though the sample looked acceptable. The last condition, which is a condition in a sale by both sample and description. So this one implies that the goods must correspond to both the sample and the description provided in the contract. So if goods fail to correspond or to match either the sample or the description, the buyer has a right to reject them. So this was seen in the case of Nicole versus Goetz in 1854. So the seller agreed to deliver oil described as foreign refined rape oil, and also provided a sample of that oil. So the bulk of the oil delivered matched the sample but did not match the description. I agreed to deliver oil described as foreign refined rape oil and also provided a sample. But then the seller ended up delivering the oil that matched only the sample but didn't match the description. So the outcome was, court ruled in favor of the buyer, emphasizing that the goods must satisfy both the sample and the description. So the buyer had a right to reject the goods. So we look at the implied warranties. So we said the conditions are more important than the warranties. The warranties are less important. Yeah, so the first warranty we have is the warranty of quiet possession. So this warranty ensures that once the buyer purchases the goods, they are entitled to use or possess them without interference or disturbance. So this is the warranty of quiet possession. The buyer is entitled to use or possess the goods without interference or disturbance, and if a third party with superior rights or the true owner disrupts the buyer's possession, the buyer can claim for damages. Like you buy land, you're entitled to use it and possess it without disturbance or interference. But in case someone comes out and say they are the true owner of that land and they disrupt your possession of the land, then the buyer has a right to claim for the damages caused because they breached the warranty of quiet possession. So this warranty is often connected to the implied condition of title, as disturbances typically occur when the seller does not have the right to sell the goods. This warrant of quiet possession ensures that the buyer will enjoy quiet possession of the goods unless the disturbance was disclosed before. Then we have the second warranty, which is the warranty of freedom from encumbrances. Warrant of freedom from encumbrances implies that goods are free from any charge or encumbrances at the time the property passes to the buyer unless it has been disclosed beforehand. So the goods should be free from any undisclosed financial claim, for example, any unpaid debt. If it is land, like the previous owner doesn't demand anything, like there is no one who has any claim with that land, so it must be free from any charge or encumbrance at the time the property passes to the buyer, unless it has been disclosed before the contract. So if goods are later found to be subject to any undisclosed charge, for example, if a car is sold but it still has unpaid repair costs, so this warranty would be breached. So the goods must be free from any charge or encumbrances at the time property passes to the buyer, unless they disclosed it before that this car has unpaid repair costs.